Hello, everybody. Thank you for joining us today. I hope to, by this presentation, to clear up some things and give you information about the whole issue of UIF benefits around the lockdown and for a 3-month period. Basically, that's what the government's aiming at. So we're going to go through it step by step. The questions are at the end, as Karima said. So I hope to answer most questions as we go along, but if you still have any remaining things, I don't say that I necessarily have all the answers, but I'll be able to help you with most of it. We are all doing educated guesses, very much so. So this will be basically a PowerPoint presentation that you can follow on your screen. Let's kick off with the introduction. First of all, we all know that we are in a compulsory lockdown period at this stage, and it has been extended, as far as we know, for now, until the end of April. What it says in terms of the regulations is that no employee may present themselves at the workplace except exempted employees whose job functions have been determined to be essential services. Now, that may be essential services, either the whole business may have to function to provide the essential service, or it may be part of the business that only some of the staff are necessary to produce the essential services. So what the regulations have also said is that it is up to the head of the institution to actually indicate who is the person, who are the people that has to be working partially or full-time or remotely to provide those services. Remote work, if that is the type of maybe your accounting services or your HR services, if you have that in your company, they may be able to work remotely, whereas maybe some more of your operational staff may have to physically do the work. Where employees cannot work remotely or at all, there's no work available. Those employees will not work at all. And from a legal point of view, no work, no pay. That is for employees who do not work. Now, although that is the legal position, the government has implored employers to try and assist as much as possible, if they can, to actually keep on paying their employees, or then make use of one of the options of UIF benefits that's available if they are unable to pay salaries, whether it's partially or in full. There was some initial confusion because the regulations have basically said that you must close down totally to get some of these benefits. That has subsequently changed. I will explain how that works. So I'm giving you the options in this presentation so that you know what will be best suited to your business. Now, there are basically two scenarios where the employer is still operating or where the employer has closed down, either fully or partly. And I will discuss these sections A to G, either when leave applies or existing UIF options for reduced time. The one that we will discuss very in detail is the UIF COVID-19 TERS, which seems to be the preferred avenue for most employers and also for the government. I will discuss illness benefits, workmen's compensation, where the COVID-19 disease has now also been recognized as a workplace disease for purposes of workmen's compensation, and then death benefits. Now, those apply in the other situation, most of it the same exactly, except that there's also, if the employer is closed totally, there's a national disaster benefit. That hasn't gotten a lot of airtime, and I think that was one of the very first options when the lockdown was first announced, and people seem to prefer rather to go the tourist routes or some of the other benefits, but we'll get into the details. As I said, the other options also apply in that scenario. Let's first look at leave. Now, in terms of uh, contractual labor law, the time of taking leave is usually by agreement. Now, that can be the employee applies for leave and it's acknowledged and it's approved by the employer, or there may be policies or in terms of the contract where it says who decides on the leave, or there's a closure at the end of the year, for example, where employees are obliged to take leave. There can also be bargaining council agreements, etc., etc. And if you can actually now tell your employees that you expect them to take paid annual leave during this period. It hasn't been tested in the courts, but the sort of the general consensus of the lawyers out there is that that shouldn't be a problem. Lots of employees have said they've been forced to take leave, but the option is, if you think about it, if you cannot afford to pay them salaries, but you have an annual leave provision, it's basically a choice for them to say either it's no work, no pay, or you can take your annual leave and get your whole salary. So also issues to take into consideration, however, to say, okay, well, maybe it's not a good idea to allow them to take annual leave now, or to tell them to take it, is that they may not have enough accrued leave, and they may have to go into a negative. And also the employer may not be able to afford paying the full leave. And that is then where it comes in that consult with your employees, consult about the various options available. It may be that they take some leave, others are covered by benefit, because I think the aim for everyone is to try and get your employees as close to what they would normally earn. And that won't be necessarily possible only from the UIF options. So let's go through those options and you can see what you can consider. First of all, long before this closed down and the coronavirus, there's been an existing UIF benefit, which is for reduced time. Now, obviously, all of these options that I'm going to be discussing now has to do only or applies only to employers who are actually registered with UIF, the Unemployment Insurance Fund, which basically all employees and employers are by law obliged to comply with and make monthly contributions to. It's 1% of salary. So those of you who don't know about that, all of these things have been aimed at people and employers who are compliant with the law to assist them, and statutory regulation. So if you are an employer who's been registered with UIF and has been paying over your monthly contributions, there is a pre-existing employee should you, for example, put your employees on short time. Let's forget for a moment for about coronavirus. Let's just say for normal economical reasons, you have to put your people on short time. Then this benefit has always applied and is applying still and will apply after the lockdown. So in that is when an employee's reduced income is below the benefit when they get when they're totally employed. So maybe you, instead of 40 or 45 hours a week, you put them on short time that they work 2 weeks from the month, or they work only a limited number of hours or days in a week. So their salary or their income will be reduced. There is, however, limits in terms of UIF. For example, they have a credit system where the employee does not get the remainder of their salary if you put them on short time. It's linked to a certain amount of credits, and the credit is 1 day for every 4 days work. And there's also a percentage of salary sliding scale. So like I say, again, it's not necessarily the full salary that they will get in the end, but they will get a capped and calculated benefit according to the UIF system that will assist them in giving them more income than just the short-term income that you are paying them. Just remember that, especially I think once we start going back from the lockdown and people want to maybe use this scheme, if you want to put people on short-term, especially with bargaining councils and contractually, you can't just do it unilaterally. You have to actually, if there are in the bargaining council agreement, there are certain requirements of consulting or talking to unions or whatever the case may be, to actually put in place those short-term arrangements. But if you do them, then you would be able, or your employees would be able to qualify for this particular benefit. Okay, so how do you apply for this? Just briefly, it's all in your handout. The employee can apply themselves or be assisted by the employer who can go online and do the application. Excuse me. There are forms that the employer has to complete. There must be a letter in this time that the employer that the reduced time is due to the COVID-19 disease and lockdown or reduced operations. There's the application form. There must be a bank form that's completed by the bank or confirmed by the bank about the banking details and a copy of the employee's ID. Employees, the payment, the benefit that's paid is the difference between what the employer will pay and the normal UIF benefits payable if the employee is totally unemployed. Because remember, UIF actually is there if an employee is dismissed for whatever reason, they can claim UIF, which is that calculated benefit up to a certain amount on a sliding scale. And that is what they would get if they are fired, if they are dismissed. Now, in this case, for reduced time, they get the difference between what you pay them for the short-time work and that benefit that they would get if they would be dismissed. It's paid directly into the employee's bank account by the UIF. And theoretically, as I say, this benefit, because it existed all the time, it's not a new thing, can be paid up to 12 months, subject to the employee's available credits. Those employees that's been working for a long time will have built up lots of credits. People who have not been employed may have used up previous credit and had to start anew. So it all depends on how many credits they have. So in summary, just a little graphic to make it easy. It's in your handout as well. The business introduces short time, and it's linked to the usual UIF benefits. It's calculated at a certain scale, and it's linked to the credits that the employee have. The employer can apply on behalf of the employee, especially now where we are sort of not necessarily at work or at office. The employer may have to assist employees to do that. And then just again a summary of all the documents and everything that has to go with the application. There is also a facility that the Department of Labour has made available. If there's more than 50 employees that you employ, there is a line that you can phone the Department of Labour's Rapid Response Team, where they might come to site and then assist you to do these applications, because there's a lot of paperwork involved if you have a lot of employees. So just to know that that facility is also available. But the next option, and as I say, it hasn't gotten a lot of airtime, and because I think it's gapped, you'll see, it's the National Disaster Benefit. That was the very first thing that was actually promulgated when this lockdown started. Once again, only employers registered with UIF would qualify, but this is not linked to the normal credits and benefits. So that whole issue of an employee must have worked 4 days to get 1 day's credit, that doesn't apply here. So it's specifically to do with to help everybody that is impacted by the COVID-19. And it's a flat rate of 3,500 Rand per month per employee. If the employer has shut down for a period of, for the period of shutdown, or 3 months, whichever is the shorter. If the shutdown exceeds 3 months, that would not apply. And one, I think that one would go back then to the normal UIF benefits, the one that I've just discussed now. And also you may not apply for this one together with some other UIF benefits. So you have to exercise a choice in which one you want to apply for. I think this will probably only really be for your lower earners because it's basically on the level of minimum wage. The application, it's very similar to the others. All the items are there. Once again, the employer applies. On behalf of the employee, you can email it to the Department of Labor. I will give you the contact details at the end of the presentation. Once again, the employer has to fill in the necessary forms. There must be a letter to say that the layoffs are due to, or the closure is due to COVID-19. The application form by the employee, the bank details confirmed by the bank, and then the copy of the employee's ID. Summary, just a little graphic again. Business is unable to pay employees because it shuts down. You are entitled to benefits that doesn't have to have credits for the employee. It's a flat fee of 3,500 Rand. It's for the duration of the shutdown, or 3 months, whichever is the shorter, and you cannot apply for this together with any other UIF benefits. And as I said, you would probably revert back to normal UIF benefits after the 3-month period, or after the shutdown is lifted. Right, and there is just a summary again of all the application requirements. Okay, now the one that seems to be the preferred benefit or option. There's also been a lot of confusion about this one, and as I said, as it came out at first, there was a lot of really, you didn't know how to interpret it, and then there were amendments made on the 8th of April to make it much broader. And once again, it's only employers and employees who are registered with the UIF that would qualify. And also, again, it's separate from the normal UIF benefits. So those credits of 1 day for every 4 days worked also do not apply. The requirement is that the business must be either partially or totally closed for up to 3 months. Now, initially it was only the business must have been totally closed. So a lot of people who only had some of their people work and not all, did not apply, qualify for this. This is now changed, and if the business is even partially closed or only some job functions are operational, the employer would still qualify to apply for this benefit. A further requirement is that for the employee side, you must be able to show that there's loss of income due to reduced work, and it's related to COVID-19. So there must be a loss of income on the part of the employee. Initially, it said that the employer must show that it is in financial distress because of COVID-19. That has fallen away. It is now the employee that must demonstrate that he or she actually has a loss of income due to reduced work, and the reduced work is related to COVID-19. The requirement is the employer cannot fully pay employees, and the employer in this stage applies online, and there is a very specific full application procedure with very specific documents that must be complied with. That is what we will deal with next. Right, so what are the features? Once again, you cannot claim this TERS, we call it COVID-19 TERS benefit, together with, for example, the reduced time benefit. You must exercise a choice. It supposedly has a faster turnaround time because we all know that UIF can be very slow. They're not very functional, although a lot of extra resources, I imagine, has been put in place. What they've done for this particular COVID tours, because that's the option that most employers go for, they've now just opened up a separate online portal. I give you the link later on in the presentation, where you can access all of the stuff and see what you must do and register and all of that. But they do say that it's supposed to be a faster turnaround time, and that the first application that you make, that you should be able to get payments once it's approved within 10 business days. The benefit that you can get is for a percentage of the employee's salary only. Okay, so it's not if you pay other contributions or allowances or bonuses, it's not included. So they take the employee's salary and they work out a percentage on that. But that salary that they take has got a cap. This maximum salary that they will use is 17,712 Rand per month. So if you work on the sliding scale that the UIF uses, they use a 60% for the lower earners and 38% for the higher earners. Then 38% of 17,712 is 6,700 odd Rand. That is the maximum benefit that an employee will be able to get in terms of this benefit. The minimum benefit, even if the percentage of salary goes below that, but it will remain 3,500. So in short, the benefit in terms of this that an employee can get is between 3,500 and a maximum of 6,730 odd Rand. Okay, so if you then say, but I partially pay my employee, or let's say they get that benefit, can I top it up? That was another question that was also a lot of confusion about. And the answer is yes. If your employee normally earns higher than 6,750 odd Rand, and that's all that they can get from UIF, you can still, if you are financially able, make up the deficit between that and their normal salary, or as much as you can afford to pay. So there is a top-up from the employee or from the employer. I will go through the various payment options with you now. Firstly, let's just see what you must do to apply. As I say, there is an online portal, but the main thing to kickstart this is that you send a blank email to this email address here. You will get an automatic reply back with details of exactly and annexures of exactly what you must submit and complete. And all the templates, everything will be included in the return email that you get. There's also one very important aspect of this is a memorandum of agreement, or MOA, that must be in place between the employer and the UIF. Now, what you will get with your email that comes back to you is an already signed agreement where the employer then says, I agree to this. Basically, everything that's in that document. So it's a standard document. It's not open for negotiations. I think when you're a bargaining council and you apply on behalf of people in a sector or employers in a sector, there may be more room for negotiation. But singular employers, like I think most of you are, you have to basically agree to the standard agreement. And then you send that back to the UIF with everything completed. The actual document, if you want to see an example of that MOA, you can find at the link here. It's our website, and you can find the link there, and you can have a look at what it says. Okay, other things that you have to include, for example, to send to them proof of your payroll for the last 3 months. There must be a letter of authority from the CEO, signed by the CEO or the managing director or the owner of the business, to say that this application may be made. There's a template that you must complete with the employers and employees' details. And they will require a spreadsheet. I see they only ask for it in CSV format with all the employee salary details, etc., etc. But they provide an explanation to you in terms of how to prepare that. There's the portal that you can go to register and to get more information. It's quite new, so I only saw it for the first time this morning, or maybe it came in yesterday, but that should also be helpful. Okay, the summary of the application process, therefore, you get an automated email from the Department of Labour back to tell you, and there's all the stuff that we've discussed, the letter of authority, the MOA, the template, and the spreadsheet with the salaries. You send that back to the provided email, and they process the claim from your downloaded spreadsheet according to their calculations. Now, you may have a calculation done, but if there's a difference between your calculation and that of the UIF, the UIF's calculation would obviously prevail. And then payments thereafter would be, like I said, the first payment would be for the first period of 30 days. And that should happen within about 10 business days. I'd say should, because we don't know yet in practice. And then there will have to be an update of the documents. If anything has changed, or maybe some employees have resigned in the meantime, you have to update for the second payment if your business is still claiming. And that will be for the second period of 30 days, and then it can only be for a maximum of 3 months. So there can be at maximum a first 30 days. You are, however, if anything changes, or if you resume operations, maybe the lockdown is lifted, you are obliged to actually let the UIF know that you have resumed operations, or to what extent. You cannot keep on claiming while you are running your business, even though you may still be in financial distress. They have to know exactly what's going on in your business. Otherwise, you would be claiming under false misrepresentation. So what are the payment options? It depends obviously on what they say in the MOA or the agreement with the UIF. And a very important thing is whatever payments the fund pay over to the business to pay out to employees, it must be subject to audit, and it must be traceable, because they have to be insured. It's public funds, and they have to ensure that it actually reached the employees. So they will calculate the benefit, and then there's a number of options. Either you can pay the employees, or the bargaining council can pay the employees directly, and then invoice the UIF for reimbursement. It's also been an issue of contention, this one, as to can you do that, or have to wait for the UIF because they take a lot of time and your employees are suffering. It seems that you are able to pay, and then the benefits that the UIF is available to be paid to employees, you can invoice them and you can get the money back to that extent. The UIF finance will pay the benefits to the employer. You will pay the employees directly. If you have fewer than 10 employees, however, they will ask you in the application to give the employees banking details. If you have fewer than 10 employees, then UIF won't pay you to pay them. They will pay the employees directly. There's also an option that the UIF can have an agreement with private banks to be able to pay employees directly. So how that option works, I'm not entirely sure, but apparently it does exist if companies want to go that route. And as I said, employer with fewer employees, they will pay those employees directly from the UIF. All right, there are just a couple of provisos that they made very clear in the amendments. The UIF benefits do not become part of the employer's general assets. Now, that's important specifically for banks, because let's say the money is paid into a business banking account, and you are over your overdraft, or you owe the bank money. They cannot refuse to release that money, the UIF benefits, and say, but you owe me money, so I'm setting this off. against your debt you owe me. It's specifically promulgated in the legislation that the banks, for example, have no claim on that money, and it must remain available for the employees. Same thing, of course, you cannot just use that money for something else. That's why they want to have it able to be audited to make sure that the benefits actually reach um, the employees. If you've paid them and you claim reimbursement, once again, if you can do a reconciliation and the audit will show that you only get the money that you have already paid out, that should also be fine. And then the other proviso, but I don't think a lot of this audience specifically fall under a bargaining council necessarily, but when there are sector bargaining councils who has entered on behalf of the sectors into a MOA for this specific benefit, and it has been extended to all parties, all employers and employees in that sector, then employers who fall under that sector and who's covered by that may not put separate claims into the UIF. They will have to go to the bargaining council who administrate the claims on their behalf. All right, so just briefly, let's run through the summary of the options. An employer who has the finances available and who can pay their employees before getting UIF benefits, they can pay their employees. The process payroll is sent to the UIF, and they can claim back the benefit after they have paid their employees. But they have to provide proof of payment to the employees to the UIF. An employee who lacks available finances to pay out or advance salaries or benefits to employees, they forward that to the UIF. UIF Finance will pay the benefits over to the employer, and you will then pay the employees. And once again, you have to submit proof of payments to the UIF. If you are a bargaining council, then it's a similar process. It goes via the bargaining council, and the bargaining council will then liaise with the employers in terms of paying out to the relevant employees or employers. And then once again, if it's a UIF banker, then that option applies as well. All right, so that was the TERS benefit. If you have any questions about that, because as I say, there's been a lot of confusion and there still is confusion, but contact us if you have any questions. We'll try and help best we can. Those are basically the salary recovery or reimbursement options that you have. Then there's also, in terms of this TERS, the illness benefit, and specifically there's two legs to that. First of all, that has always been there. It's normal UIF illness benefits. When an employee has been unable to work, we'll look at that now. And then the one that comes also from the TERS, which is when an employee is under quarantine for up to 14 days. They may not necessarily be ill, but they have to be quarantined because they've been exposed to, they might have it, or they've been in contact with someone. So they might be ill, but we don't know. So the normal UIF illness benefits, where you have to have a medical certificate that says you have to be booked off, you are ill, would not apply for a person in quarantine. That's where there's a difference. So the normal UIF illness benefits, as it would apply, any employee who is sick for more than 7 days and their paid sick leave is exhausted can apply for this. And there's the requirements the employee applies. It's like when you dismiss to apply for UIF. If you're sick for more than 7 days and you don't have any sick leave, paid sick leave left, you can apply for this to UIF if you have the credits. And there is you must provide a medical certificate, the forms must be completed by the employee, and the employee must give an ID. Now the quarantine, that's the one you're interested in from the employer's perspective during this time. It's during the lockdown period, and it only applies to essential workers or people who are now busy with essential work. So if the employee is placed on special leave for quarantine and they cannot report to work, then the first 14 days, they can get this benefit and no medical note is required for this first 14 days. Only in a letter from the employer and employee where they both confirm that it's a situation of quarantine due to the coronavirus protocols. So then they can get this, we call it illness benefits, but it's not really illness, it's quarantine or special leave. And what you must complete there is the forms completed by the employer, the bank form, the employee's ID. Should it go beyond 14 days, then there is another form UI3 to be completed, and then after a period of 14 days, a medical certificate has to be provided. So then it's no longer just a letter between the employer and employee agreeing that the employee is on special leave due to quarantine. The online application can be done by the employer at the youth filing website or an email to the contact details which I'll give you. And just remember, there is such a thing, like we said, workman's compensation, where the employee contracts the virus due to exposure. I'll talk about that a bit later, but you cannot claim this quarantine benefit if you also claim for workman's compensation, for COIDA. So it's one or the other, depending on the situation. Okay, so just the summary, just again for easy reference, where the individual employee is quarantined for 14 days, the benefit is linked to the usual UIF structure. The credits would apply 1 day for every 4 days worked. You can apply either for normal illness benefits if that's better. So if you're quarantined for 14 days or less, these are the requirements here. The application, the forms that you have to fill in, no medical certificate for the first 14 days. And then if you are quarantined for more than 14 days, it's the same situation, but you have to actually then provide a medical certificate, or the medical section on the form must be completed by the doctor. Okay. Now here we come to the COIDA, or workman's compensation, where it says if an employee is absent due to contracting the coronavirus out of and in the course of his or her employment. Now this is important because you cannot just say an employee who happens to work for you and now tests positive has necessarily contracted the virus in the course of their employment. That will have to be proved to the UIF's satisfaction. And what I have said so far in the briefings that we've received, for example, if you work in a hospital, you're a high care provider, and you're treating coronavirus patients, and now you contract the virus. It's sort of an obvious link, or it will be easier accepted that the person is actually qualifies for the compensation. It's from the date of diagnosis up to 30 days later that you can qualify for this benefit. It is 75% of the employee's monthly earnings. That's the benefit. And the employee has to notify the employer and the compensation commissioner in writing. And then the normal claims procedures, doctor's reports, resumptions report, I would assume, would apply as you would for any injury on duty or contracting a communicable disease on duty. Okay, and then the last one is when an employee unfortunately dies as a direct result of COVID-19. Once again, the UIF has got benefits, and it's also they've always had death benefits. They've just now added the whole issue of die as a result of COVID-19. Once again, the employer must be registered with UIF. The normal benefits apply, and what does the application entail? The people who can apply for this is a close relative. They give their definition of who that is. I'll touch on that just now. Close relative of the employee who died, or the person who's been nominated by the employee as the beneficiary. They can apply. They can email the application to the nearest Department of Labour Processing Centre, or online. The employer can assist with that by way of the online U-filing portal. The employer have to complete those forms, the required forms that you see there. The application forms for the deceased application. There must be a copy of the death certificate. The bank must confirm the banking details of the beneficiary. And then there must be a copy of IDs of both the employee and the applicant, who is the relative or the nominated person. So let's look at it in more details. When the employee dies, close family or nominated person, and that would be spouse or life partner, children, or any nominated person by the employee. They apply for the benefit directly to the UIF, but as we see, especially in these times, the employer can assist them to apply electronically because the UIF offices aren't as such open. It's linked to usual UIF benefit structure, and as such, it will be linked to the 1 day for every 4 days work credit that the employee would have built up during the course of employment. There is a list of the application requirements. We've already discussed that, just for easy reference. All right, there's the list of the contact details. It's in your handout. Fax to email as well as mailbox. But as I say, especially if you go for the tours, there's this new portal. So I would go and have a look there and see if that makes the administration of this somewhat easier. All right, so those are all the questions, all the material that I can share with you. If there are any questions now, maybe Kareem, you can assist us there.
Thank you very much, Judith. There are a few questions. So the first question is, 2 years ago, I got retrenched and I collected UIF. Then I decided to open my own small plumbing business. Business is very slow. Can I go and register for UIF?
Okay, so are you it depends if the person is the employer, he's got his own business, but is he just a sole self-employed, or does he have employees? If he is an employer, then obviously he can apply for benefits for employees, which may include himself if he is an employee of the business. If he is a sole person with only his own himself doing the work, or he's got fewer than 10 employees, then definitely you can apply. I think that reduced work benefits might apply, and maybe even the TERS. But you can, the TERS is basically for employers. So if you're an employee, if you're self-employed, you can apply in your personal capacity for UIF.
Okay, thank you. And then the next question is, if the employer and or the employee are not currently registered with UIF, can you register and back pay the UIF fees to be able to then claim?
You know what, that they have not specifically said, but I remember in the beginning when they first came out with this, the Minister of Labour sort of had in the briefings indicated that if people have not registered, then he said they would help them to get into the system. So I don't have a sure answer on that, but what I would suggest is that they contact the UIF and explain the situation to them and see if they can actually do so. Because I think from the government side, they are trying to help as many people as possible. So, and they want people to be regulated and to be in the system. So they might well be able to assist people to do that.
Okay, and then the next question is, Hi, I don't have a payroll system. What should I submit in this regard?
I'm not sure what to tell you, but I think also again contact the UIF helpline when they send you the any sort of emails. Explain to them what your situation is, because what they want is an Excel spreadsheet. So it may not have to. It's not a payroll system in the sense that you use VIP or any of these payroll systems. They want details in an Excel spreadsheet. So I think if you can provide that in the format that they want, they should be able to assist you.
Okay, and then the next question is, I pay some of my employees, sorry, I pay some of my employees in cash. What happens in this case?
I think you, I think you're going to have to be able to prove the payments, and at this point, cash payment is going to be a problem. So maybe if you can set up a system, especially you won't be able to get the payment to them now anyway, if they're not allowed to work. If they do work and you pay them in cash, if you want to claim back from the UIF, you're going to have some or other um, protocol in place that the UIF can actually make sure that the money has been paid. So you're going to have to set up something, is my assumption.
And then the next question is, can self-employed persons claim COID or UIF, meaning a doctor or an owner of a business?
Um, yeah, I think I've answered that question before. If it's just you yourself, you claim in your personal capacity as a former employee who is now not working, you should be able to do that. Employer implies that you have people working for you. And you may be one of those people that's on the payroll if you have your own business. If it's just you, a single person, then you might have to contact them in terms of your personal capacity.
Okay, and then the next question is, question regarding TERS benefit. Will TERS tell you, the employer, how much is paid to the employee to know how much the difference is to pay the employees? The difference if possible.
Yeah, I would assume so. The process, as I understand it, is that they get your payroll for your Excel spreadsheet, they do the calculations, they send it back to you, or they send a calculation or a summary of the calculation or however much it is back to you in terms of what is payable from the UIF. And from that, you should be able to work out what the balances are and so on and so forth.
Okay, and then just the last question for the session. How does the employee show they have loss of income? Is this with the bank statement?
Um, Yeah, that's a difficult one because it doesn't say, but if you can show that there's reduced work, that would imply that there's reduced income. So I think it is linked to loss of income as a result of reduced work. So the proof will be the reduced work that would imply automatically loss of income. I think if you're for the tourists, in any case, that is the case.
Okay, thank you. And then we have another question that just came in. Good day. Registering for TERS on the normal application forms allow UIF and the Department of Labor to investigate your company books. If I pay
Yes.
my employees beforehand and claim back from UIF, will UIF or the Department of Labor still reserve the right to investigate my company's books?
Definitely. Um, in the beginning, they said that businesses must have a dedicated separate account or create one, where the UIF benefits will have to be paid in and then paid out to the employees. They've taken that away, and they said that it can be paid into the employer's business account, but then it must be set up in such a way that the payment trail can be audited by the UIF. I won't necessarily say all business books, but in terms of the payment, where it was paid and where it's gone from being paid over from the UIF, that it actually reached the employees, or then to show that you've paid out the employees, do a reconciliation of the money that you get back from the UIF, and they must be able to audit that side of it.
Okay, thank you. I see there's quite a few questions still coming in. So the next question is, if I have only paid 1 year UIF whilst employed and now work for myself, can I claim?
Yes, remember, I think it's the TERS, it's not linked to your normal UIF benefits in terms of credits. So wherever we said that it's de-linked from the normal UIF benefits and you don't have credits, but you registered, then you should be able to claim.
Okay, and then the next question is, we don't use a spreadsheet in our business. We have a recorded month-to-month time or salary book which gets issued yearly to our auditors. We use this system because our employees don't have bank accounts. Can the UIF help us?
That you will have to talk to the UIF about. I'm not sure. As I say, as far as I know, they require a certain format for the administration. So if you want to try and see if there's an alternative way that you could do that, you'll have to sort that out with them.
Okay, and then the next question is, I have applied for COVID-19 TERS, submitting the necessary documents. However, I have only received an automated email response acknowledging receipt of my documents, but no document or case number was issued. How can I follow up, or who can I contact?
My understanding of the process is if you have received the automated answer back, there are certain documents that you have to then complete and then submit to UIF. And after that, they will then let you know if your claim has been approved or to what extent it has been approved. And then payment will happen. So I would think that you will have to contact the nearest processing center or see if there's via the portal, the new portal that's been created now, if you can inquire via that in terms of following up.
Okay, and then the next question is, I'm an employer. I employ 5 staff members. Only 2 is currently UIF registered. I, as an employer, is not registered. Can I register myself now? And the other person, 2 employees, cannot be UIF registered as they do not have a work permit.
Okay. Yes, as I said before, is you're going to have to contact the UIF and see if they're willing to put you on the system and have you back pay. For those who do not have work permits, they are basically illegals. I don't think that you'll be able to help them via UIF.
Okay, and then the next question is, if you worked for a company for 14 years and left, and now after 7 years, can I apply for UIF?
Sorry, I'm not sure I understand the question. Could you just ask it again?
If you worked for a company for 14 years and left, and now after 7 years, can I apply for UIF?
Well, if the person is saying in personal capacity, UIF is normally linked to the employee. It's not to the employer. So the employee's ID number is in the UIF system, and wherever he's worked before or credits that's been built up, that goes with the employee. So there should be something on the employee system to show that that he has credit built up and haven't received payments, and then it will be up to UIF. I don't know if they have time limits on not claiming, but it's worth a try.
Okay, and then the next question is, if the UIF has been paid to employees directly, how will the employer know payment has been made?
I'm not entirely sure, but I would suspect that the UIF will send the employer, like I say, some kind of statement or summary or to show what has been paid out, because the employer obviously, if the employer has made the application on behalf of employees, and the employees have been paid now, then there must be communication back from the UIF in terms of that. So there should be some record that goes to the employer.
Okay, and then the next question is, what if the lockdown is partially lifted and, for instance, you don't want your part of your staff members working due to the commutation risk because I run my office from home? What is the way forward?
Yeah, that's a difficult one. No, none of us know what's going to happen when the lockdown is lifted and how it's going to happen. Um, but I mean, certainly, still, if your business is closed and it's a you can show that there's good cause, good reason why you cannot resume full operations. You have to play it by ear and see, but potentially, benefits like this could continue. But as I say, we don't know exactly what the criteria of the UIF will be going forward and with lifting up of the lockdown.
Yeah, thank you very much, Judith. I believe that's it for the questions. Is there anything you'd like to add before I end off?
No, just my contact details. Our contact details are there. If there are any questions, we'll try to help. And it was very nice. I hope I cleared up some of the issues. And thank you for having me.